Welcome to FCPA Flash, the official podcast of FCPA Professor, moderated by Professor Mike Kaler. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA. To learn how FCPA Professor can elevate your FCPA knowledge, please visit www.fcpaprofessor.com. FCPA Flash is sponsored by Kroll. Kroll is trusted by companies and compliance officers worldwide to help prevent, detect, and remediate FCPA challenges with scalable end-to-end compliance solutions. From high-volume third-party screening and automated monitoring, to risk-based due diligence, to complex investigations and monitorships. With leading experts, global resources, and advanced technology, Kroll is uniquely positioned to meet all your FCPA needs.
Thank you for listening to the FCPA Flash podcast. This is Professor Mike Kaler, and I invite you to my next FCPA Institute in Phoenix, Arizona on January 11th through the 12th. To learn more about the two-day FCPA Institute and how it has elevated the FCPA knowledge and practical skills of a diverse group of professionals, please visit fcpaprofessor.com and click on the FCPA Institute page. Welcome to FCPA Flash. This is Professor Mike Kaler, and today's guest is Kevin Muhlendorf, a partner at Wiley Rein, where his practice includes an FCPA component. Previously, Muhlendorf was an assistant chief in the fraud section of the DOJ and senior counsel in the enforcement division of the SEC. In addition to his private practice, Kevin is also an adjunct professor at Georgetown Law, where he teaches complex securities investigations in the LLM program. Thanks for joining FCPA Flash today.
Thanks so much for having me, Mike. I'm excited to be here.
It's always interesting to speak to folks who not only have private practice experience, but also experience in the government. And you, from an FCPA perspective, were at both the Department of Justice and the SEC, and I interested in some of your perspectives, given your previous positions as well as current position. What is one thing about the DOJ's FCPA enforcement program that you believe is not widely understood or appreciated, perhaps by the business community?
Well, I think probably the singular thing about the DOJ program is that it is run by out of Maine justice and run by essentially now 30 prosecutors in one cohesive unit, which is different than how almost all other federal crimes are prosecuted across the country. And if you think about the reasons for that, I'm not sure it was originally thought through this way. I mean, it's obviously done for consistency purposes, but as we get into what we're going to talk about later on today, you start to think about there not being trials and that leading to a need for one sort of voice on this issue. We have the FCPA guide from 2012, but as you know, there aren't a lot of trials that sort of define what the FCPA is.
Yeah, and I think having read the FCPA's legislative history a couple of times, I think the reason for that centralized enforcement is actually historical and based upon the foreign policy implications of FCPA enforcement actions. There was a belief that you didn't exactly want an assistant United States attorney in Toledo or Wichita bringing an enforcement action concerning a bona fide traditional foreign government official. So I think that the reason for that was largely historical and a recognition of some of the foreign policy implications that could arise in these actions.
Yeah, I think that's absolutely true. I mean, you need a sort of an experience with dealing with foreign governments and dealing with obtaining foreign evidence. You could if you were sort of not familiar with the problems that foreign evidence gathering generates, you could really cause some problems diplomatically. For example, there are obviously countries that have blocking statutes where just the mere calling into a foreign country can get you into trouble if you're not cleared to do it. So that's certainly the historic reason for it. But as a practical matter, It is 40 years later, you've got a group of people sort of in the Department of Justice sitting in Washington in the bond building who are now responsible for delineating what the law is.
Yeah, and I think that raises a whole host of policy questions that I have written about extensively. Namely, we have a very small group of people enforcing a law largely behind closed doors in Washington, D.C., really in the absence of very, very little case law. And I think that does raise some very interesting policy issues.
Yeah, it does. I will say this, and look, I just got out of the department, and I'm out of the fraud section, and I'm a firm believer that the people who are there really are trying to be good stewards and great caretakers of the FCPA program. I think the past management has done a good job given sort of the constraints they have to do that. But when you don't put people to the test, right, by litigating these cases, I mean, there've been very few. You've got Eskenazi, Hoskins, and some cases like that. You really are left, with reading the tea leaves in declinations and in DPAs and MPAs about what some of these terms mean.
Yeah, and I'll ask you about some of those rule of law implications in a second, but really the same question when it comes to the SEC's FCPA enforcement program. What one specific thing perhaps do you believe is not widely understood or appreciated about the SEC's FCPA enforcement program by the business community?
So it's sort of a function of their structure. It's the FCPA is enforced in sort of a more diffuse manner there. They have an FCPA unit, and that's when Director Kazami set up the specialized units. That was one of the first 5 that was set up. But if you talk to people who do this, if you talk to some of the FCPA unit attorneys, there are cases brought from outside the unit, and the unit's involved, but it's not as centralized as it is at DOJ. And so you can have situations where you're talking to people who don't do FCPA all the time, like you would with the DOJ attorneys. The other thing that I don't think people recognize is the way that the trial unit is structured at SEC. When I was at the SEC, and so this is I left I guess like 8 years ago. It was not uncommon for there to be a complete separation between the investigative attorneys and the people who would be actually filing the cases. And so you'd work up a case and you would hand it over to a trial attorney, and there was little involvement by the trial unit in the preparation of those cases, which was not a great practice. In the last few years, that's changed. They have a process they call now affiliation, where the trial unit is involved much earlier. And it varies in degree, but that has, I think, made them more trial ready. So if that's the takeaway from the sort of development of the program over the last 10, 12 years, is that I think the SEC probably is far more trial ready than they were. I can tell you, just when I was an investigative attorney there, people didn't. Look, you were out getting evidence, but you were only thinking about how it was going to be used at trial, and I think that's something that they have worked to change by getting the trial attorneys involved in investigations earlier.
Well, trial ready, I guess, only in theory, because there's never been a fully litigated SEC FCPA trial in literally 40 years, and really no company, at least to my knowledge, has ever put the SEC to its burden of proof in FCPA history. That's a pretty remarkable statistic, given that we're talking about a statute that is very soon to turn 40 years old.
Yeah, no, that's true, and there's a whole host of problems, I think, that flow from that. But I do think that even if companies aren't taking the SEC to trial or taking the DOJ to trial, there is a benefit, especially in the SEC's case, to being trial ready, in the sense that I think, if you're going to go in there and negotiate and do and there's some actual real advocacy being done, them being able to push back with some actual, this is how we would prove it at trial, literally, not just sort of in theory, I think is beneficial to the program, because it elevates it for both sides. But you're right, there hasn't been a trial, so we haven't seen that. Although I guess there's a couple individuals who are I just filed summary judgment motions recently, so we'll see how that plays out.
Yeah, and I'm not saying that individuals have never filed pretrial motions to dismiss that have either been granted or not granted. I'm referring to a fully litigated type case. Now, in recent years and weeks, for that matter, to make it even more recent, there's been a lot of talk by high-ranking DOJ officials about the rule of law. And these speeches have not necessarily been in the FCPA context, but I'd like to make some of these recent speeches perhaps FCPA relevant. So, for instance, a high-ranking DOJ official recently said the rule of law refers to the principle that the United States is governed by law and not arbitrary decisions of government officials. Rule of law systems are characterized by consistency and predictability. Now, it's hard to disagree with the validity of those statements, but in your opinion, is FCPA enforcement consistent? Is it predictable? Or perhaps are there too many situations which seem to be driven by arbitrary decisions of government officials?
Yeah, so I think, and let me start by saying, I truly believe that the folks who are the enforcers, right, the SEC and DOJ, really do strive for that consistency. That doesn't mean they're getting it, right? And I think the problem in having sort of a less than perfect or a less than adversarial system is that, the fear of losing, right? The fear, it really, of being put to the test really sharpens your focus. And I think that, if you are forced to how am I going to try this case? How am I actually going to prove this in court and get past some of those objections? I think some of the stuff that we see being talked about in these settlements would fall away. And I think that's where you have a lack of consistency. I mean, think of it this way. We talk about the sentencing guidelines, we talk about individuals and companies, and the whole point of that is to avoid unwanted sentencing disparities, right? That's one of the reasons we have them. And I don't think that when we're coming in and especially you've talked about this before, but on the SEC front, it doesn't seem that we get some clarity into disgorgement calculations and things like that.
Yeah, and I was an FCPA practitioner for nearly 10 years, and I understand that what you see in a settlement document may not necessarily tell the whole story. And when asking this question to others, they say basically, well, if you knew what we knew, it would look to be consistent and predictable. And my response to that is, even accepting that as true, we now have a transparency problem with transparency is part of the rule of law as well.
Yeah, no, I think there should be, we would all benefit from more clarity in declinations where things are set out, not just that the company cooperated, but, what was really going on behind the scenes. Look, the answer to why people settle these cases and are willing to agree to some of these things is it may be that there was really bad behavior, right? Or there was a terrible compliance program, or they bought a company that had a real problem, and so you are willing to get out any way you can. And I think the other thing is, if you think about it if you're representing a company, you may not want all that put out there, right? So it may be that you're perfectly happy at defending a company to have it be a very anodyne statement.
Yeah, I completely agree with that, but the DOJ and the SEC have, and I use this term loosely, a duty to defend the resolution documents they create. And, it's interesting to note how literally some of these enforcement actions, the substantive allegations, are like sometimes a page long, but we'll see what happens. In the FCPA context, the name of the game is often cooperation. Yet, what is your thought as to whether too many companies, for lack of a better term, are just simply rolling over and playing dead? For instance, in recent years, there have been two unanimous Supreme Court decisions against the government on statute of limitation issues, most recently the Kokesh case from earlier this summer. Yet tolling agreements or waivers of statute of limitations seems to be the name of the game in FCPA inquiries. Do you think that more companies should fight back? And really, since when is not cooperating to assert a right you don't have not cooperation?
No, I do agree. I think that a lot of times it seems from the outside, at least, like companies are going in paws up, right? Here we did this thing. It was 10 years ago. Please let us pay to get out of it. I don't think that that's necessarily the right decision. I mean, it's obviously fact dependent, right? There's a whole host of things that you lose when you do that, right? I mean, one of the things that I like to focus on, and sort of what I do is, look, I was at DOJ and SEC, and I think if you dig down as a defense attorney in actual litigated cases, you find a whole host of problems that are engendered by that parallel enforcement, right? Things that are withheld that shouldn't have been withheld, things that are done that shouldn't have been done between the two agencies, and you lose the opportunity to exploit those things. I think that is something that is problematic because you're not getting the benefit of all your options. That said, look, if you've got some really bad behavior, obviously that's something you might just want to you might want to conclude quickly and move on. One thing I'll note, I went to the enforcement manual just because I was kind of curious, because we're actually teaching it tonight in that Georgetown class, to see what it said about cooperation in the SEC's enforcement manual. And it has a section on tolling agreements, and it obviously has a section on cooperation. Not signing a tolling agreement isn't listed as failure to cooperate. Cooperation agreements, if you sign a cooperation agreement, require tolling. But that's not something that's explicitly set out, and it shouldn't be, right? I mean, it's a right you have, and there's a reason we have statutes of limitation.
Yeah, I mean, that reminds me of there was an enforcement action a few years ago against a Japanese company, and the DOJ specifically said in the resolution documents that the company failed to cooperate on jurisdictional issues. And my response to that was, raising jurisdictional defenses is now failure to cooperate? Raising legal defenses is failure to cooperate? That's pretty dangerous, in my opinion.
Yeah, and I'm surprised. It's surprising that would be there because I think the reality is, I think, it might stick in someone's head that you refuse to do it. And you often hear this mantra, well, you don't want us to have to make a hasty decision. I don't believe that if you take at face value, and I really do, that the people in those units wouldn't do that, wouldn't charge a case they couldn't readily prove, they weren't ready to prove, then I don't think that should be a consideration, this sort of hasty charging thing. I mean, one thing people forget, though, and you can't, at least in the criminal context, you can't pass over this, is, the department can always and frequently go get the statute of limitations suspended if they're seeking foreign evidence. So, and you don't know that that's happened, right? That's done ex parte and under seal. When I was at the department, I only knew of one instance where that was unsuccessful on a first attempt. So, in some ways, since these cases always involve foreign evidence, other than making someone go put that application in, which is a low standard, right? It's I think a preponderance of the evidence standard. Not signing the tolling agreement may not have any benefits, right?
No, you're absolutely right on the DOJ criminal standpoint that it's suspended, tolled, what have you, for this formal foreign evidence gathering request. In the aftermath of Kokesh, some FCPA commentators were saying, oh, this is going to be a sea change going forward. And I was of the opinion and still am that, well, no, it's not, because the law, even unanimous Supreme Court decisions, don't matter when you simply roll over and play dead when you're under FCPA scrutiny. And indeed, since Kokesh, there's been 2 SEC enforcement actions, which have included many, many millions of dollars in disgorgement that were beyond any conceivable statute of limitations. So what impact do you see Kokesh having?
it in some ways, I mean, it should, and maybe we'll see as we get a little further away from it. It gives you some more pushback in the negotiation. I mean, you should be pushing back with that, right? And saying, okay, well, how government, how SEC would you prove that? You can't. It's outside the statute of limitations. And again, it's easier in some ways in the criminal case where you could charge a conspiracy. I think you should definitely push back, and I think that it does increase leverage. I mean, one thing that should be happening though is if you're going to sign this tolling agreement, I think given Kokesh and in the SEC context, you really have to look at the agreement and make sure it's as narrowly crafted as possible, right? I mean, I think that's one of the things that's being litigated in the Octaf individuals is how narrowly were those statute limitations. I mean, those tolling agreements crafted, because it would be unfortunate that you had a broad one when you could have gotten rid of some dollars at a very minimum.
But even in the criminal context with conspiracy, correct me if I'm wrong, but the statute of limitations begins to run when the last act in furtherance of the conspiracy occurs. And in many of these enforcement actions, based upon the actual allegations, even that last act is long beyond 5 years.
Yeah, no, that's true. But I mean, if you think about 5 years plus the 3 years for the suspension, right? So you're talking about 8 years. That's still, I mean, most of them are brought within that time frame, although there's some that aren't.
Yeah, no.
I think the other thing to remember when you're considering Kokesh and this whole issue of tolling agreements is, the lifespan of an FCPA trial attorney at the department is probably 5-6 years. I mean, management's obviously been there a lot longer. You lose agents, you lose prosecutors, and it gets harder, as cases get older. So in some ways, drawing it out, the conventional playbook is that's better for a defendant, right? It sort of goes both ways, though.
So the FCPA is turning 40 in a couple of months, and many of the guests I've had on this podcast this year, I've been asking the same general question, and that is, do you think the FCPA has been successful, or as successful perhaps as it could be, in accomplishing its objectives?
I think anyone that says it's been as successful as it could be, that's sort of the answer to that should be always no, because I think we can always do things better, both the department and people on the defense side and companies and compliance programs. But yeah, I do think I think in the 40 years, I mean, I think if you don't see a sea change in how companies behave, I think that you're not looking. I mean, we regularly talk about how much better compliance programs are, and people really do think about that. And I think, at least at the department, because that's my most recent experience, they do take that seriously in deciding what to do. I mean, I think that is an important distinction. I think also the way that some other countries have developed their programs is certainly could be better, but it's improving.
I agree with you. Go ahead.
No, I would say one of the things that I found most striking recently was we taught, in addition to teaching at Georgetown, we do some teaching at something called the International Law Institute, where they train foreign judges, and we recently taught sort of a white collar survey to some foreign judges from West Africa, and I was shocked and sort of stunned that they got the most animated about the FCPA, and they were really angry. I mean, I'm surprisingly angry that the United States is not doing more to prosecute the fraud recipients, the bribe recipients in their own countries. That really upset them that we weren't doing more to stamp out fraud in their countries.
Well, I mean, one can only look to another country thousands of miles away to perhaps solve some of their own problems, but I hear your point. I want to go back to something you said. I completely agree that there has been a sea change or a noticeable increase in compliance over the last really decade, but what has that yielded? It's yielded not less FCPA enforcement, it's yielded more FCPA enforcement. It seems a bit counterintuitive that the more compliance companies have, the more FCPA enforcement activity there has tended to be.
no, I mean, I take your point, but at the same time, I think if the goal from 40 years ago was to stamp out corruption, right? I think the notion that companies are behaving better and installing these programs is a good result. I don't think that necessarily the two are tied together, the increase in enforcement actions and the increase in compliance program. I mean, I think one of the reasons we're seeing more enforcement actions is simply more bodies, right? And it has become a very singular focus for the department and the SEC because of the headline grabbing amounts that you get out of those settlements. So I think that drives.
Yeah, let's not forget there's also more options to resolve cases. For the FCPA's first 30-odd years, you either charged or you didn't charge. Now there's almost like this buffet line. You charge, you don't charge, MPA, DPA, declination with disgorgement. Obviously, the more options you have, it stands to reason the more quantity of cases you're going to have, but that begs the question of whether quantity is being elevated compared to quality.
Yeah, no, I mean, certainly that gets to the point I was talking about earlier, is that with this sort of, as you put it, buffet of choices, it makes it a lot easier to not push the government to prove its case, right? If it's easy, if you can get out, and it's not illogical to say, okay, if I can get out with an NPA, then that makes a whole lot more sense than 5 years of fighting the government, to get to a trial, where I might very well win, but is the juice worth the squeeze, right?
That's a good way to end. Is the juice worth the squeeze? Today's guest has been Kevin Muhlendorf. He's a partner at Wiley Rhine with an FCPA practice. And thank you for sharing your insights today with FCPA Flash podcast listeners.
Thanks very much, Mike.